Jefferson County Court at law number 2 is now in session. The court is in session and calls number 23 CCCR 0292. Case is styled the state of Texas versus Nikhil Prescott. Ms. Prescott, would you please come forward? Ms. Prescott, your full name is Nikhil Prescott. How are you doing, Ms. Prescott? Okay. Now, Ms. Prescott, the state is represented in this case by attorney Haley Simmons. And Ms. Simmons, how are you doing?
I'm great, Judge. How are you?
I'm doing fine. Thanks for asking. Probation office is represented in this case by Mr. Gary Gilliam. Mr. Gilliam, how are you doing?
Very well, thank you, sir.
Okay. Now, let's see. State, what is your recommendation in Ms. Prescott's case?
Your Honor, the state has sent a dismissal in for the MTRP asking it should be continued on probation. And I believe probation has a separate request. And we've put that amendment up here for you, Judge.
Okay. Do you want to hold the 40 hours of community service in advance? Is that correct?
Yes, sir.
Okay, hold on a minute, Prescott. Okay, so she had 1 year deferred probation on June 28th. Okay, hold on. Yes, yeah. Probation was amended. 6 months. So, she was given probation in June 21st of 2024
Yes, sir.
for a year, and then it was extended for another 6 months, which will be December of 2025.
Yes, sir.
Okay. Okay, so yes. Okay, Mr. Prescott, the court will be amending the terms and conditions of your community supervision and the motion to revoke your unadjudicated probation will be dismissed. You'll be able to get a copy of the amendment. Now, do you have any objections to the amendment that the probation office is recommending?
No, sir.
Okay. All right. And this is your signature on this document, right?
Yes, sir.
And prior to signing this document, did you understand everything in this document?
Yes.
And is everything in this document true and correct
Yeah.
to the best of your knowledge? Okay. Ms. Prescott, you'll get a copy of the dismissal and the order amending the terms and conditions of your probation. And once you get that from our court coordinators, you'll be free to go.
Thank
You have a
so much.
blessed day and take care of that baby of yours.
Yes, sir.
You're welcome. Oh, mine is still acting up. I'm gonna have to use yours. We need to get. I did that yesterday. It didn't work.
There's two over there now.
Jefferson County Court at lot number 2 is back in session. The court is in session with the motion to revoke probation docket and the announcement docket. First case is cause number 25 CCCR 1752. Case is styled the state of Texas versus Emily J. Adams. Ms. Adams is appearing via Zoom. Miss Adams, how are you doing?
Hey, I'm good, Your Honor. How are you?
I'm doing fine. Thanks for asking. And Ms. Adams, you're representing your case by your attorney, Attorney Tom Kelly, who is present in court. And Mr. Kelly, again, how are you doing?
Great, Judge. How are you?
I'm doing fine. Thanks for asking. State is represented in this case by Attorney Haley Simmons. Ms. Simmons, again, how are you
I'm
doing?
great, Judge. How are you?
I'm doing fine. Thanks for asking. And Mr. Kelly, what is your announcement in Ms. Adams' case?
Judge, there is one case obviously pending in your court, and there's still one that I don't think has been received by the DA's office. Ms. Simmons checked on that for us this morning, and I just, as much as I want to proceed on this case, I want to make sure that that case is either coming and I can handle it, or it's not coming and I can handle this one. So,
What's the status of that?
I'm not sure, Your Honor. I do believe it's actually listed under Andrew Hubel, so I'll have to go check with upstairs to see if anything. Emily Adams, she's on Zoom.
Yeah.
And I'll double check to see if we have anything that's coming. I'll reach out to the department. But I just briefly checked this morning. There's nothing received.
so really just my long-winded way of asking for some time on this one.
Okay. Do you see anything? Well, if it wasn't filed, we wouldn't,
I already
you wouldn't be
know.
able to see it.
Right.
I'll
Yeah.
see if she went to.
Okay. Okay, give us, oh, you
Yeah.
can.
Yeah, look, my husband, I don't.
Okay,
She went to jail on.
okay, Okay. okay, give us a reset date.
December 17th.
Okay, this case will be reset to December 17th, 2025. And Mr. Kelly, you can get your reset.
I will, Judge.
And Ms. Adams, stay in contact with your attorney, your bonds, but they will give a notice of your reset against your case is reset to December 17th, 2025. You're free to go and you have a blessed day.
Thank you, Your Honor.
Okay. Now did William Gary Jones show up? Okay, Mr. Jones, would you please come forward? Mr. Jones, your full name is William Gary Jones?
Yes, sir.
How you doing, Mr. Jones?
Yeah.
I'm doing fine, thanks for asking. Mr. Jones, you're represented by your attorney, Tom Kelly. Mr. Kelly, what's your announcement in Mr. Jones' case?
Thank you, Your Honor. We're going to make an application for pretrial diversion. There's just one discovery issue that I need to clear up to make sure that we're not like an automatic rejection or anything like
Okay.
that. So if we can have some time for that, we'll be.
Okay, now, I think pretrial diversion is in the month of December,
Yes, Your Honor.
so we'll reset this till the second week in December.
Sure. That sounds
Okay,
great.
give us a reset date. We want the same day, December 17th.
That's a Wednesday. You don't want it, you want it on Monday.
It's up to him. You want it on Monday or Wednesday?
Either's fine. I'll be here.
That day?
Yeah, yes.
Okay.
Okay, so it'll be December 17th.
Perfect.
Okay, this case will be reset to December 17th, 2025 at 9 a.m. to give your attorney opportunity to apply for pretrial diversion. Now, Mr. Jones, you're gonna get your reset from our coordinator. Once you get your reset, you're free to go and you have a blessed day. And Mr. Kelly, I think this is his last case.
And here it is, Judge. Thank you
Okay,
very
you're
much.
free to go and you have a blessed day. Lidris Javon Love.
Thank you, Your Honor.
You welcome. Mr. Love, your full name is that Ladris?
Ladarius Love,
Ladarius Javon Love. How are you doing, Mr. Love?
right,
And Mr. Love, you're represented in your case by your attorney John Macy. Mr. Macy, how are you doing?
I'm fine, Your Honor, thanks for asking.
That's good. The state is represented in this case by Mr. Samuel Masradian. Mr. Masradian, how are you doing?
Doing well, Judge. Thank you.
You're welcome. And Mr. Macy, what is your announcement in Mr. Love's case?
Your Honor, I'd ask for a standard reset. For whatever reason, even though I requested a discovery over a month ago, I got most of it yesterday. And I got the rest of it, the videos, today. I haven't even seen them. So I just asked it just so I can do my due diligence in the case. I got an offer, but I hadn't even looked at it.
Okay.
Okay, so if I could get a standard reset.
Give us a reset date.
December 8th.
Okay, this case will be reset to December 8th, 2025. Mr. Love, you get your reset from our coordinator. Once you get your reset, you'll be free to go and you have a blessed day.
Thank you, Judge.
And is this the only case you have, Mr. Macy?
I have the sentencing this afternoon, Judge, but yes, this morning was the only case this morning.
Okay, all right. All right, we'll see you this afternoon.
Thank you, Judge.
Helen Kathleen Reyes. Mm,
Warren.
Good morning. How you doing, Ms.
Very
Reyes?
well, thank you, sir.
That's good. Now, Ms. Reyes, your case is set for an announcement. What is your announcement in the case?
Pretrial. I need to go to pretrial motion.
Okay, so we need to, now, Ms. Reyes, let me, do this. I think we've had a pretrial hearing before, right?
Yes.
And so, the court would actually, well, recommend that you just, whatever pretrial motions you have, you need to file all of them.
Yes.
And so that we can hear them all at
Yes.
one time, instead of filing one and then,
Sure.
then do another, then another,
Absolutely.
okay? Okay, so we're going to, we'll give you a pretrial date.
30 days.
No, it's gonna have to be after 30 days. It may have to be, because we have to get with Ada, the court, reporter, January.
What date? I mean, you want to say?
Right.
Thank you. What time, what other Monday, Judge?
Probably toward the end of that week,
So just a Thursday, maybe?
Thursday
The
afternoon.
whole. Okay, thank you. I just added it for the whole week. We could do it probably that Thursday maybe, we could do it.
Thursday, we have the jail run.
You know, we don't start, you could do it at 9 if she, cause the jail run gonna start at 9.
Yeah,
But you wanna just do it at 1:30?
that's what I'm thinking, the afternoon would be better.
That's a good time. 1:30 at, on that Thursday?
Yeah, what date is, you say that's the 12th? What date is
No,
that?
January 15th.
15th, okay,
We gonna do it on,
okay,
and you said at 1:30.
yes. Okay, okay. Okay, you get your reset, cases reset for pretrial hearing on January 15th, 2026 at 1:30 PM. Okay, stand over there. Once you get your reset, you're free going, you have a blessed day. To Nick Moles? What? No, I have it. Yeah, I do, yes, go ahead on and print it. I'm just gonna read it to him. You might not need to print it.
I don't need to, okay.
Okay, this is cause number M327790. Cases style of state of Texas versus Tanika. How you pronounce your middle name? Your middle name? Danielle Mose.
Yes, sir.
Okay. And Ms. Mose, how are you doing? I'm doing fine. Thanks for asking. Ms. Mose, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay. Now, Ms. Mose, you may put your hand out. I have before me a motion to revoke your probation.
Mhm.
This motion was filed by the Jefferson County District Attorney's Office.
Mhm.
In this motion, it alleges that you, Tanika Danielle Mose, was tried on May 6th of 2022 for the offense of driving while intoxicated with an alcohol concentration level of 0.15 or more.
Yes, sir.
The court found you guilty and assessed punishment at 180 days confinement in the Jefferson County Jail and a fine of $800. Your probation, well, your jail time was probated for a period of 12 months. In this motion, it alleges that during your probation, that you, Tanika Danielle Mose, failed to pay court assessed fees as ordered by the court, and as of January 27th of 2023, you were $1,520 in arrears in violation of condition 8 of your probation order. Allegation number 2 alleged that you failed to perform community service hours required as ordered by the court in violation of condition 18 of your probation order. Now, Ms. Mose, if the court finds that any one of these allegations are true, you could be assessed up to 180 days in the Jefferson County Jail. Do you understand that?
Yes, sir.
Okay, now, could you hand this back
Yes.
to her? Now, Mr. Gilliam is handing you a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. I'm going to go over that document with you. That document states that as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Do you understand that option?
Yes, sir.
Number two, if you want an attorney but do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Do you understand that option?
Yes.
And number three, you may represent yourself. Do you understand that option?
Yes, sir.
Now, the first paragraph below number three, it's the one sentence paragraph, states that if you want an attorney and you have enough money to hire an attorney, your case will be reset to give you time to hire an attorney. Do you understand that?
Yes, sir.
Now, the next one sentence paragraph states that if you want an attorney but do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you, but you must first fill out a financial questionnaire so that the proper person can determine whether or not you qualify for a court-appointed attorney. Do you understand that?
Yes, sir.
Now, the next paragraph is for individuals who will be waiving their right to an attorney or giving up their right to have an attorney and representing themselves. That paragraph states that you may not speak to the prosecutor, which is the assistant criminal district attorney. You cannot speak to the prosecutor about your case unless you first sign a written waiver of your right to be represented by an attorney. Now, that is only for individuals who will be requesting a court-appointed attorney. Who will be requesting time to represent themselves. Do you understand that?
Yes.
Now, That next paragraph, which is in block form, and this is for individuals who will be representing themselves. It states that you should be aware that there are dangers and disadvantages of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you in your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Do you understand that?
Yes.
Now, that last one sentence paragraph is for individuals who will be representing themselves. It states that if you're representing yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Do you understand that?
Yes, sir.
Now, at the bottom of that document in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, then you'll place your initials on the first line to the left.
Yes, sir.
If you've already hired an attorney to represent you, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, you'll place your initials on the third line to the left. If you have already been appointed a court-appointed attorney in this case, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right.
Yes, sir.
Now, if you would like to waive your right to an attorney, that is, give up your right to have an attorney and represent yourself, then you will place your initials on the fifth line to the left.
Yes.
Now, once you have finished initialing one of the 5 lines that I've just mentioned, then you will sign your name on the line that is titled defendant, and you will sign today's date on the line that is titled date, and the day's date is October 29th of 2025. Do you understand?
Yes, sir.
Okay, you can go ahead on and make your choice and sign and date that form. Thank you. Okay, now, Ms. Mose, I have before me a document that's titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? And are these your initials on the line that states you'd like to have your case reset to hire your attorney?
Yes, sir.
Now, before you signed and initial this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge? Okay, Ms. Mose, your case is going to be reset to give you an opportunity to hire your attorney. Our court coordinator will give you your reset. Once you get your reset, you will be free to go and you have a blessed day. Please stand in front of the court coordinator. And Mr. Gilliam, you're free to go and you have a blessed day.
Thank you, sir.
you aware that the court does not get involved with plea bargain agreements?
Well, I've heard you say
Listen,
that.
okay, you heard me say that. You have been practicing law for quite a number of years, and you know that the judge cannot enter into a plea bargain agreement between you and the state. That's only between you and the state. So,
She's not given, the
Okay,
state is
well,
not giving me a
listen.
lot of leeway.
okay, well, you can set it for
We
trial.
just negotiate.
If you don't, you have two options. You can accept or reject the offer. Now, if you reject the offer, we can set the case for trial. And then the jury could decide,
She'll agree to a sentence.
listen, Mr. Lawrence, I can't get involved in the plea bargain agreement. So any discussion about the plea bargain agreement, that should be between you and the state, not between me and you, or you and I.
Well, we can have just a regular sentencing hearing if you like to do that, but the trial, no trial on guilt and innocence, but we can have a sentencing hearing.
Now, you say the sentencing here, is your client pleading unagreed?
Right.
Okay, well, you still have to sign the paperwork.
We've done the paperwork, but we're not,
Did you send it in?
it's been, I think we did one time, the thing's messed up somehow. But we've changed, since then, we've rediscussed the terms of the sentence.
Right, we negotiated the offer.
Well,
it hasn't been
well,
changed.
well, my understanding is if it's an unagreed plea, there is no agreement with regards to the punishment. The court will set the punishment anywhere within the punishment range. That's what happens on an unagreed plea.
I don't feel comfortable moving forward on an unagreed plea where you haven't even requested discovery.
Now, I think y'all might need more time to talk.
She's willing to accept,
Mr.
A certain
Lawrence, Mr.
range.
Lawrence, Mr. Lawrence.
the defendant is willing to accept a
Now,
certain range.
Mr. Lawrence, you're talking about what the defendant is willing to accept. You're putting the cart before the horse. Okay? And that just simply means that you have to do the paperwork first.
Which we've already done.
Okay? Send it in to the prosecutors.
Your Honor, he did one form. There's 4 cases. There is an agreement to plead a 3 and dismiss 1. He sent 1. He wanted to negotiate the terms back there, which we agreed to the terms he gave us. And it hasn't been corrected on the file, so we still don't have any agreed paperwork to send to the court.
So you would have to,
Well, we'll renegotiate.
We
okay?
renegotiate.
Now, as a lawyer, we must uphold ourselves to certain ethical standards.
Sir?
As a lawyer, we are required to hold ourselves to certain ethical standards.
Yes.
Okay? And one of the things is we should be cordial with each other.
Yes.
Okay?
I'm hoping that a day
Okay,
around.
okay, listen now. Okay, that day is now. It's every day. as a lawyer.
Oh, I
And
didn't
if
know
you,
that.
well, you didn't know that, you need to read the ethical rules. You're aware
Well,
of
I
that.
have tried to be, but my
Okay, okay.
opponent is not
Okay,
trying to be.
this right, okay, what we're talking about is, if you're gonna negotiate, have the canons in mind that we are all required to uphold ourselves to, okay? And so we do not, should not holler or scream or yell at the other lawyer, okay?
My
And-
ears
and
are
that's-
stopped up, Judge. I can't hear.
Okay, your ears are stopped up.
Yes,
You just heard me.
yes, I can hear you speaking on the
Right,
microphone.
you just heard me and you said your ears were stopped up. So they're not stopped up to the point where you can't hear me.
I'm
So,
not trying to yell.
okay, do not yell, okay? And make sure that you are cordial with the other attorney.
I've tried to do that every
And
way I
well,
can.
you just have to be patient and, you know, just continue to try to conduct yourself accordingly.
Maybe it'd be better if you understood the situation.
No, now, Mr. Lawrence, I told you I can't get involved in the plea negotiations. I know that may be frustrating to you, but that's just how it is. I can't get involved in that.
Well, there are points we come to where the opposing counsel
I understand, but I can't
refuses
resolve
to
that.
listen.
I can't resolve that. Well, that's why I say, you know, we have ways to settle disputes. One way to settle a dispute is with a trial.
And
then-
I've explained to the opposing counsel, the only trial worth having is a sentencing hearing.
Okay, well, and as I explained to you earlier, with the sentencing hearing, if it's an unagreed plea, the defendant entered a plea of either guilty or no contest to the charges. And then, once we get into the punishment stage, because, you know, we have a bifurcated system. And then you have the guilty and innocent phase. If the person enters a plea of guilty or no contest in the guilty and innocent stage, then we go to the punishment stage. And at the punishment stage, the judge or the court sets punishment. Now, the court can hear arguments from both sides, but then at that point, the court will assess punishment anywhere within the punishment range.
Yes,
Okay, and that means that it can be, if it's a class B misdemeanor, anywhere from 1 day, 0 days to 180 days in the county jail. The court can give a fine up to $2,000. The court can give both a fine and a fine and jail time. The court can give either deferred probation or unadjudicated probation or adjudicated probation. No, anywhere within that punishment range. And so that's what's available to the court. Okay?
Your Honor, I could make it a lot simpler for you to understand.
But what you was talking about is punishment. And so in order to get the punishment, we can, you know, you have to fill out the paperwork with regards to your client, you know, signing the misdemeanor plea admonishment, the discovery certification. Okay, once those documents are signed, and also you have to fill out the plea form showing that it is you do not have an agreement. Then once those forms are filled out, we'll go through the process of the first phase where your client enters a plea of either guilty or no contest. And then from that, we'll move to the second phase, which is the punishment phase.
Your Honor, we could do that, and it would be, a lot of it would be probably a waste of the court's time.
How would it
Well,
be a
here's
waste of the
what-
court's
here's what
time if
the-
that's
Let me just tell you exactly where we stand. and
no,
then you'll see
Mr.
what's
Lawrence,
going on.
Mr. Lawrence, I can't get involved in your negotiation.
I'm not trying to get you.
Well, if you're trying to, okay, my understanding of what you're saying, you basically you said you need me to understand where you stand, and that's because you have talked to the prosecutor. Y'all have come to an impasse, I would imagine, and you want me to resolve that. I cannot resolve that.
Well, the prosecutor's telling me something I've never heard
Okay,
before.
well, I can't get involved in your negotiation.
Well, it may not be,
Well, Mr.
I
Lawrence,
thought the plea offer had to be,
that's between you and the state, Mr. Lawrence.
I thought no, this is universal rules.
Okay,
The plea offer has to be either a sentence for time. Excuse me,
I just explained to you all of the options, the same options that I have in terms of it could be a fine, it could be jail time, it could be jail time and a fine, it could be unadjudicated probation, or it could be adjudicated probation. Those are the
you don't
options.
understand. It can be, the way it is, they've offered,
I don't need to know what they offered.
well, yes, you do.
No, I don't, because
To
we're not,
understand how they're violating the rule.
we're not in the punishment stage.
To understand how the state is violating the rule, you have to understand. They've offered 90 days
Okay,
or
what-
1 year.
What rule are you talking about? Where is it in the code of criminal
She
procedure?
has a choice.
Okay, tell me what rule that she's violated and show me where
Well, I
it
believe
is in the
Rule
law.
32 is the rule that deals
Rule
with
32.
plea offer.
Okay, you say rule 32. Let's look up rule 32.
I didn't bring my book.
Well, I have a book here. I have a bunch of books here.
Well, this is just the rule on plea offer.
Okay, hold on a minute. We're gonna get to the rule of plea offers.
All right.
Let's see. Okay. Article 32.01 of Texas Code of Criminal Procedure states defendant in custody and no indictment presented. That's what that rule is about. Article 32.02 talks about dismissal by state's attorney. Article 32A.01 talks about trial priorities. Those are the only rules that's here. So where's rule 32 that you're talking about?
I may have them confused. This is real simple, Your Honor. We're being
Okay,
told,
but you're saying that it was a rule that was violated. I'm looking for the rule that you said was violated.
well, you have to know what the prosecutor's telling us. We can't do.
No, we have to know what the rule is to see whether or not it's been violated.
Well,
We
we're being-
apply the
We're being
facts. to
told
the
we
rule.
can only have it one way and we're supposed to be able to have.
Now, you're aware that the state do not have to make an offer. It's not a right.
Well, I would say that the state's offer is unconstitutional.
Well, if you think it's unconstitutional, you can file.
But
Nope,
in order for
whatever.
anybody to proceed on it, you have to know what I'm talking about.
Okay, well, let me do this here. I can't get involved with your negotiation, and we talked about that, and we've been talking about that for the last
Well, we can
10
have,
minutes. We can just
we
set it
can
for-
have an unadjudicated appeal, I suppose.
Well, we can have whatever, but we got to get to the point to appeal it. You got to dispose of the case to appeal the case.
Well, then you have to know what the state's telling me.
No, I don't have to do that. If it's gonna be appeal, we'll have. Okay, you're gonna file, well, first of all, you're gonna enter a plea, you appeal your case. And then let the Ninth Court of Appeals determine whether or not, we
What we're
did
being
anything.
offered, it makes it impossible to plead. What we're being offered is an impossible plea.
Oh, well, Mr. Lawrence, we've, talked about this for a while. The state is not willing to renegotiate. The state did, say something earlier.
We amended the terms of the offer at his request to what he was asking for, Your Honor. We have renegotiated, which we agreed to. We asked him to correct the paperwork and send it back, not in just one actual misdemeanor plea admonishment, but all three. and we did agree to dismiss the other. The plea is not impossible. The client is just rejecting the plea offer, which
Okay.
means we should set it for trial.
Okay,
The plea offer is 90 days over 1 year, and we're being told that
Mr. Lawrence.
she cannot choose
Mr.
just
Lawrence.
one.
Mr. Lawrence.
We're being
Mr.
told she
Mr.
cannot
Mr.
choose just to
Lawrence,
take the
Mr.
90
Lawrence.
days.
Mr. Lawrence.
She wrote
Lawyer-
the 90-day
Mr.
sentence.
Lawrence, if you raise your voice again, I'm gonna hold you in contempt of court and put you in jail.
I
Okay?
have no other way
Get
of
a,
telling you.
get the bailiff,
I have no other way of telling you.
okay?
Well,
Hmm. Okay, I'm gonna tell you this again. If you raise your voice again, you will be held in contempt of court and placed in the Jefferson County Jail. Do you understand?
Well, I can just write everything.
Do you understand? That's my question. If you do not understand, do not raise your voice. You don't have to hand me anything. Okay, you say you understand in writing, okay? Well, make sure your performance reflect your understanding.
Your Honor, I did not know I was raising my voice. My ears are stopped up and I have to put it at a certain level.
Okay, now you just lowered your voice.
I may have, Your Honor, I cannot hear it that well.
Okay, but you hear you hear good enough to lower your voice.
I don't know what
Okay,
you're talking.
so at this time, what we're gonna do, these cases are going to be, now, we either gonna, if the cases are not gonna plead today, we can reset the cases.
It can plead. It can plead.
Okay, but Mr. Lawrence, if it's either you're gonna accept or reject the offer. If you accept the offer, fine. If you reject the offer,
It's an impossible offer.
okay, so it's rejected. So let's do this here. We're gonna set these cases for trial. Give us the trial date.
We don't
In
want to
January?
try. We want to plead.
Ma'am, you are not.
Okay. And I assume that, okay. Well, once you go outside with your client and sign the paperwork.
Okay. 90 days jail.
Okay,
That's what you want.
just go in and just go and talk to your client. Okay. Yeah, and y'all can go outside to do the paperwork.
Okay. May I explain something? My client wants to accept the
Ma-
90 days jail. She
Okay.
doesn't care about the rest of the plea offer.
Okay, well, Mr. Lawrence, you can go outside and talk to your client about that.
The prosecutor is refusing to do it the way we are offering to
Well,
do it.
just go outside and talk to your client. Okay.
You ready for him?
Yes.
Good morning, Judge.
Hey, good morning, Mr. Bennett. How are you doing?
Doing well, thank you, guys.
That's good. Now, Mr. Bennett, you're representing your case by your attorney, Attorney Giles Cole. Mr. Cole, how are you doing?
Great, Judge.
Okay. Now, Mr. Cole, what is your announcement in Mr. Bennett's case?
Judge, we received this offer, and we're just trying to decide whether or not this is gonna go to trial. I know the next days after minute, so.
Okay, so you need that conference with your client?
Yes.
Okay. Give us a reset date. We're gonna reset it. We're gonna keep it on the announcement docket.
Who is it?
This is the first one, Benny Roy Bennett Jr.
Yeah.
No, just a standard reset. Okay, this case will be reset to December 17th, 2025 at 9 a.m. You're gonna get your reset from our court coordinator. Once you get your reset, you're free to go and you have a blessed day.
Thank you, Sheriff's Office.
You're welcome.
All right.
Okay.
Yeah, just have to see right.
She refuses to accept
Oh,
probation.
listen. Hey, hold on a minute. I just need to know. Okay, the court is in session in four cases. Clause numbers 25 CCCR 1718, clause number 25 CCCR 1719, clause number 25 CCCR 1900, and clause number 25 CCCR 1901. Both cases are styled State of Texas versus Esperanza Zapata. Mr. Potter, is that your full name?
Yes, sir.
How are you doing, Mr. Potter?
I'm doing okay.
That's good. Now, Mr. Potter, you're representing your cases by your attorney, Attorney Jack Lawrence III. Mr. Lawrence, how are you doing?
Just fine, Your Honor.
Okay. And state is representing this case by Attorney Haley Simmons. And Ms. Simmons, again, how are you doing?
Nothing better, Judge, thank you.
And now, Ms. Simmons, you have relayed an offer to Mr. Lawrence regarding these cases. Is that correct?
That's correct, Your Honor. 2 offers have been relayed. There was an original offer, and then with the request of defense, we did negotiate down further. Do you want both offers read to the court?
Yeah. What is the, I guess, yeah, you can read the offers.
Your Honor, the original offer before the court was on calls 25 CCCR 1718, 180 days probated over 15 months with a $500 fine, 40 hours community service, fetch class and court cost. This is to run concurrent with 25 CCCR 1719, 180 over 15. The fine was to be waived, 40 hours community service and court cost. State agreed to dismiss calls 25 CCCR 1900 with plea to the 3 companion cases. Calls 25 CCCR 1901, again, 180 days probated over 15 months, fine to be waived, 40 hours community service plus court cost. There was no restitution in either theft case. After further negotiation at the request of defense, everything was to remain the same outside of the probation being dropped for the duration and the actual probated amount to 90 over 1 to run concurrent again with 1718, 1719, 1901, and still dismiss the 4 companion.
Okay, now, Ms. Zapata, you heard the offers that the state made in this case.
Yes, sir. I believe it was 90 days and a year probation. What I
Okay.
wanted to know was about the like how much I would be paying every month on probation.
We'll let you, once we get to that point, we'll let you know. Okay? And then there's some things, if you found to be indigent, then the court can make some adjustments. Okay? Indigent means that if you can't afford it, then the court can make adjustments. Do you understand that?
Yeah.
Okay,
If I may, I can break it down a little slower with agreement for counsel to explain to the defendant exactly what's on the table.
okay.
Do I have your permission?
The client, and I have already discussed this, but you have my permission to explain to her, but she is just taking one of the options.
Okay,
The state's offered 90 days probated over 1 year. That 1 year is the duration of your probation. You would be required to report monthly to probation. You do have a $500 fine in the first case, ending in 1718. There was no restitution, so no restitution is to be paid back. 40 hours community service, that is to be completed throughout your terms on probation, so probation would handle all that. Court costs as well, of course, if there is any finding of indigency, which the defense counsel relayed to me, which is why on the remaining 2 cases that you were going to plead to, if you choose to accept, those fines were waived. We took that into consideration.
Okay.
So you do have a 1 year probation. We dropped it from the original 15 at the request of your attorney.
Okay, that's fine.
you accept that?
Yeah.
Okay. Okay, so we just need
We need the paperwork.
the paperwork.
Correctly.
Okay.
Question? What question?
Okay,
On the plea offer of, I believe it's 90 days, jail probated over 1 year.
Uh-huh.
Were you willing to just discard the probation part and just do the 90 days jail?
I mean, if she would allow me to do that, that would be, that's not, if that wasn't the agreement, I can't, if I can't, you know.
That's what you want to do. Is
I did just wanted to take my time because I know being on probation would be harder for me to, you know,
Okay, well,
to do, but if she's not allowing that, then I can't, you know, go against what she's allowing.
As I expressed to defense counsel, we do support a probation offer, just given the amount of cases in this court, and we do feel some accountability would be sufficient.
Hmm?
So we're offering probation.
they're not offering jail time.
But she's rejecting the possibility of probation.
Oh, well, if she rejects, so she's rejecting the plea.
Hmm?
Is she rejecting or you?
So if, no, let me,
Yes.
okay, let me ask her.
If,
Do you want to accept the probation or not? The state is not offering jail time.
You just want the 90 days jail?
No, listen, that wasn't my question. My question is,
if I don't finish the probation, how you guys would want me to finish,
I can't give you legal advice on how to proceed.
there's somebody, yeah,
You have
right.
to speak with your defense attorney and.
So what she's basically saying is that the state is offering you probation. They're not offering you jail time.
okay.
So, do you
Yeah.
accept the probation or not?
Yeah, I guess I'm gonna have to just take probation.
Well, I mean, you have options. You can go to the court on punishment. You can go to trial. I mean, you still have options. Okay.
Yeah.
What do you
What
want
did-
to
so-
do?
so-
You
right.
say, you tell the judge what you want to do.
I guess I'll take the probation, it's fine, I like that.
Just want to ensure it's free reign voluntarily.
Right.
Your Honor.
Right. You can't be in a position where you're taking it because it has to be freely, voluntarily, and knowingly entered into your pleas of when you enter into a plea. Okay. You have to know what you're doing. It has to be violent. In essence, you cannot be coerced or forced to enter into a plea agreement. Do you understand that?
Yes, sir. Yes, sure.
Now, if you think you're being forced or to enter into this plea agreement, you don't have to enter into it. It has to be voluntary. You have to do it of your own, I can say volition, but of your own free will.
It's because I don't wanna have the motion to revoke or things like that,
Well-
I mess up on probation, it's just doing that is gonna,
Well,
is the whole thing where I'm coming from, but I mean, if you guys are not willing to.
well, that's the offer that the state is making. Now, you can accept or reject that offer.
Yeah, I'm gonna just accept it, that's fine.
Okay. Okay. So let's to be frank, I'm not too comfortable
I'm not as well.
in going forward because at this time, it doesn't seem to me that you're entering into this plea agreement voluntarily. You understand what I'm saying, Mrs. Zapata?
Yes, sir.
And now we're not trying to rush to judgment or force you to do something that you're unwilling to do, that you're not willing to do. Because an agreement, it has to be agreed to by both parties. It's kind of like a contract,
Okay.
okay? And I don't want to use no legal terms like meeting of the minds, but you have to be in agreement with what the state is offering, and you can't be forced to do it. Okay, do you understand that?
Yes, sir.
Okay. So at this time, the court is not gonna, if there's a plea bar, the court is not gonna go along with it at this time. Okay, we'll give you some time to reflect. Y'all can consider the options that I just mentioned. And so at this time, the court is not going to go forward with accepting this plea agreement. Okay. So what we're gonna do is just reset the case. Give y'all some time, give you some time to reflect, give you some time to talk, confer with your attorney, and look at other options that you may have.
I'll take the probation, just so.
No. Listen, what I'm saying. What you said, you're telling me I'll take the probation because I don't have no other options. And so in essence, you're saying I'm being forced to take something that I don't want to take. And so what I'm trying to get you to understand is that we can't force you, and you shouldn't be forced to take something. You understand what I'm saying? So that's why it has to be voluntarily, freely and So I'm gonna give you some time to uh, talk to your attorney, and he can tell you other options that you may have. And as I mentioned to you some other options that you may have. Okay, but so at this time we're not going to go along with it, but we'll get you back up before the court.
Okay.
Okay, it's just that we don't want to rush to judgment and do something that seemed to me that's kind of inappropriate in view of the fact that
It's a good deal for me. It's a good deal because like if, she said a year probation, that's fine for me. I mean, it's just my thing is with paying and,
I understand. We understand that. But as I
but
mentioned,
like Mr. Baylor told me that you will be able to.
as I mentioned to you earlier, there's some other options that the court can consider if
Right.
you're found to be indigent, meaning that you're unable to pay it. There's some other options.
Then explain to me like, wasn't being explained to me all that. When she had to come out there and tell me.
Okay. I'm just letting you know that there's some other options. You don't have to uh, think that uh, you're going to be put in a situation with this probation where you can't pay, which means we're setting you up for failure in essence, because if you can't not pay it and then and you're forced to take it, so we could be setting you up for failure. So, but we don't want to do that. There are some options that the court has, but before we get into all of that any further, you can talk to your lawyer. The lawyer could explain that he's been here before. He knows the options that the court has, that the court have, and so also he's also aware that pleas have to be voluntarily, knowingly, and intelligently entered into, and so we can't just force you to enter into a plea agreement. Okay, so what you need to do is just kind of take some time and sort everything out with your attorney and look at the options all on the table. Then you could come to an intelligent decision, one that you're comfortable with, and that you don't feel that you're being forced to take.
May I speak, Your Honor?
Yes.
I'd be willing with defense counsel and his client, and of course approval of the court, to sit down with them and discuss the offer to her with his permission. That way we could all be on the same page if he were wanting and she were wanting to move forward today.
Be fine.
Okay. Okay, I'll give y'all time to do that. Okay. Okay, let them, they need to talk. Okay. This is cause number 25 CCCR 0810 case of style, the state of Texas versus Jeffrey Justice Guidry. Mr. Guidry, is that your full name?
Sir.
Mr. Guidry, Mr. Guidry, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Now, Mr. Guidry, I have before me two documents. The first document is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? And is this your signature on the line that's titled defendant?
Yes, Your Honor.
And are these your initials on the line that state you like to waive your right to attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of entering a guilty plea or proceeding to trial. Do you recognize this document?
Sure.
And is this your signature on the line that's titled defendant? Mr. Guidry, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Sure.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. Now, Mr. Guidry, I'm signing these documents. You have an opportunity to talk to the prosecutor about your case. Let me see, the date is the 20. Okay. All right.
Over, we agree upon.
Jefferson County Court at Law number 2 is back in session. The court is in session in 2 cases. Cause numbers 25 CCCR 0178 and cause number 25 CCCR 0179. Both cases are styled the state of Texas versus Desire Danae Johnson. Ms. Johnson, is that your full name? Now, Ms. Johnson, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Okay, you may put your hand down. How are you doing, Ms. Johnson? I'm doing fine. Thanks for asking. Ms. Johnson, you're represented in your cases by your attorney, Attorney Todd LeBlanc. And Mr. LeBlanc, how are you doing?
Good.
That's good. Now, Mr. LeBlanc, do you waive a record in Ms. Johnson's cases?
We do, Your Honor.
Ms. Johnson, in cause number 25 CCCR 0178, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Ms. Johnson, it alleges that you committed the Class B misdemeanor offense of theft on December 15, 2024, while you were in Jefferson County, Texas. Ms. Johnson, do you understand what you have been charged with? And to this charge, Ms. Johnson, how do you plead? Guilty, not guilty, or no contest?
No contest.
No contest?
Mhm.
Now, are you pleading no contest freely and voluntarily?
Yes.
And are you pleading no contest because you do not wish to fight or contest the charges? Ms. Johnson, I also have before me a document on my tablet that's titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit number 1. Ms. Johnson, do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on a line next to a box that's checked no contingent. Did you place your initials on this document? On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature? And on the next document that's titled trial court certification, the defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? I also have a document that's titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant?
Yes, sir.
Now, Ms. Johnson, before you signed and initialed all of the documents that I just showed you, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Ms. Johnson, are you a citizen of the United States?
State officer states 1.
Any objections? No objections. State's Exhibit number 1 will be admitted. And Mr. LeBlanc, you've advised and counseled Ms. Johnson. Is there any evidence that she is currently mentally incompetent to stand trial?
None that I'm aware of, Your Honor.
And Ms. Johnson, your attorney, Mr. LeBlanc, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation? Ms. Johnson, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
State's offering 1 year deferred with a $500 fine, 40 hours community service, theft class court cost, and this is to run concurrent with the companion case 25 CCCR 0179.
What's the court cost?
277.
I have more if you do this week. I just got some on iCloud, okay. 11, 11:20. Okay, Ms. Johnson. The state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay a fine of $500 plus court costs of $277. You'll also be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15, and you'll be required to pay court-appointed attorney's fees of $350. Your total monthly installments, that is the total amount that you will be required to pay each month, is $186 a month. Will you be able to pay the $186 each month?
Yes.
You will also be required to perform 40 hours of community service, attend and complete a deaf class, adhere to the other standard terms and conditions of disprobation, and this case will run concurrent with the companion case, clause number 25 CCCR 0179. Ms. Johnson, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes.
Ms. Johnson, I'll follow the plea bargain that you have entered into with the state. Ms. Johnson, we will move to your next case. Your next case is cause number 25 CCCR 0179. And in this case, Ms. Johnson, I have before me document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, Ms. Johnson, in this, it alleges that Derazia, Danae Johnson, on or about December 15th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failed to identify fugitive with intent to give false information. Ms. Johnson, do you understand what you have been charged with? And to this charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
Now, are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Ms. Johnson, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments. You recognize this document?
Yes.
On page 2 of this same document, there's a set of initials, DJ, on a line next to a box that's checking over contingent. Did you place your initials on this document?
Yes.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature? Now, Ms. Johnson, I also have before me a document that is titled Discovery Certification. And Heather, do you recognize this document?
Yes,
And is this your signature on the line as title defendant?
yes.
Now, Ms. Johnson, before you signed and initialed all of these documents, did your attorney go over these documents with you?
Yes.
And did you understand everything that your attorney went over?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Stay up your seats, Glenn.
No objection, Your Honor.
No objections, state's exhibit number 1 will be admitted. And Ms. Johnson, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that you're pleading waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is that agreement?
1 year deferred, fine is to be waived with 40 hours community service and court cost.
And it's $75. What's the court cost? Okay. Ms. Johnson, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required, well, you would not be required to pay a fine because the fine will be waived. You will be required to pay court costs in the amount of $277. You will not be, and you will be required to pay a reimbursement fee of $15, and you'll be required to reimburse Jefferson County Court appointed attorney's fees, in this case, of $75. You will not be required to pay a probation fee, and you will not be required to pay your analysis fee because you're paying those fees in the previous case. Now, your total monthly installments in this case is $33 a month. Will you be able to pay the $33 each month?
Yes.
You also, well, this case will run concurrent with cause number 25 CCCR 0178, and you will be required to adhere to the other standard terms and conditions of this probation, and you will be required to serve 40 hours of community service. Now, Ms. Johnson, do you understand the state's offer in this case? Do you think that it's fair and just?
Yes.
And do you accept it? Okay, Ms. Johnson, I'll follow the plea bargain agreement that you made in this case. Now, Ms. Johnson, if you successfully complete the probationary period, these cases will be dismissed. They will not appear on your record as a conviction, and you may qualify for non-disclosure. You can talk to your attorney about the non-disclosure because he's quite competent in those matters. Now, Ms. Johnson, please stand at the end of the table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go, and you have a blessed day. And Mr. LeBlanc, you're free to go as well, and you have a blessed day. Kadeem Warren. Mr. Cole.
Let you know.
Mr. Warren, I have two cases before me. They are cause numbers 25 CCCR 1644. Excuse me, that was the case. Cause number 25 CCCR 1420 and cause number 25 CCCR 1421. Both cases are styled the state of Texas versus Kadeem Jamel Warren. Mr. Warren, is that your full name?
Yes, sir.
Mr. Warren, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Warren, you may put your hand down. How are you doing, Mr. Warren? That's good. Now, Mr. Warren, you're represented in your cases by your attorney, Attorney Giles Cole. Mr. Cole, how are you doing?
Great, Judge. How about you?
I'm doing fine. Thanks for asking. Mr. Cole, did you waive a record in Mr. Warren cases?
Yes, we do.
Mr. Warren, I have before me a document that is titled information. And this information was filed by the Jefferson County District Attorney's Office. In this information, Mr. Warren, it alleges that you, Kadeem Jamel Warren, on or about May 13th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failed to identify fugitive with intent to give false information. Mr. Warren, do you understand what you've been charged with?
Yes, sir.
To this charge, Mr. Warren, how do you plead guilty, not guilty, and no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not have to? Are you pleading no contest because you do not wish to fight or contest the charges? Okay. Now, Mr. Warren, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit Number 1. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there are a set of initials on a line next to a box that's checked, no contender. Did you place your initials on this document?
Yes.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes,
The
sir.
second box that's checked states that you are waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, sir.
I also have another document on paper that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
Is that your signature on the line that's titled Defendant?
Yes, sir.
Now, Mr. Warren, before you signed and initial all of the documents that I just showed you, did your attorney go over these documents with you? And did you understand everything that your attorney went over?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Warren, are you a citizen of the United States?
Yes, sir.
No, for State's Exhibit 1.
Okay.
No objections. State's Exhibit Number 1 will be admitted. And Mr. Cole, you advised and counseled Mr. Warren, is there any evidence that he is currently mentally incompetent to stand trial?
Right.
And Mr. Warren, your attorney, Mr. Cole, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Mr. Cole, I will accept your plea, Mr. Warren, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for 6 months of deferred adjudication, fine of $200, repayment of court costs, and 24 hours of community service. And in exchange for a plea to this cause, the state agrees to dismiss the companion case of 25 CCCR 1421 with forfeiture of the weapon in that case.
What's the court cost?
277.
And, 425. 277, you said? Okay. Mr. Warren, the state is offering that you serve 6 months deferred adjudicated probation. During the 6 month probationary period, you'll be required to pay a fine of $200 plus court costs of $277. You will also be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, a reimbursement fee of $15. You'll also be required to reimburse Jefferson County Court appointed attorney's fees, $425. Your total monthly installments, that is the total amount that you will be required to pay each month while you are on probation, is $273 a month. Will you be able to pay the $273 each month?
Yes, sir.
Okay, you will also be required to perform 24 hours of community service. And the state will be dismissing cause number 25 CCCR 1421 for forfeiture of weapon. In that case, I have before me, in that case, a document that is titled Motion to Forfeit. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled defendant? Now, Mr. Warren, before you sign the initial, before you sign this document, did your attorney go over this document with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Warren, I'll grant the motion to forfeit the weapon, in this case, to the Grove Police Department. Okay, now, Mr. Warren, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Mr. Warren, I'll follow the plea bargaining agreement that you have entered into with the state. Now, Mr. Warren, if you successfully complete this probationary period, this case will be dismissed. It will not appear on your record as a conviction, and you may qualify for non-disclosure, whereby your record will be sealed to the general public. You could talk to your attorney about the non-disclosure because he's quite competent in those matters. Now, Mr. Warren, you're going to stand at the end of that table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you'll be free to go and you have a blessed day.
Thank you.
Okay. Yes, you may be excused. You have a blessed day as well.
Yes, sir.
Okay, this is cause number 25 CCCR 0472, case of style of state of Texas versus Tamia Aura Thomas. Ms. Thomas, is that your full name? How you doing, Ms. Thomas? I'm doing fine, thanks for asking. Now, Ms. Thomas, you're represented in your case by your attorney, Attorney Jennifer DeLodge. Ms. DeLodge, how are you doing?
I'm doing good, Judge.
That's good. Now, what is your announcement in Ms. Thomas's case?
Judge, we'd like a little more time to review discovery, requesting a reset.
Okay, so we're gonna reset it to give you time for discovery.
December 17th.
Okay, this case will be reset to December 17th of 2025. Ms. Thomas, you'll get your reset from our court coordinator. Once you get your reset, you'll be free to go and you have a blessed day. And Ms. DeLodge, you'll be free to go as well and you have a blessed
Thank you,
day.
Judge. I will see you
Okay.
tomorrow if y'all want.
Okay,
Heard.
Jefferson County Court of Law is in session in 4 cases, cause numbers 25 CCCR 1054, cause number 25 CCCR 1085, cause number 25 CCCR 1086, and cause number 25 CCCR 0636. All 4 cases are style of state of Texas versus, or 3 of the cases style state of Texas versus Kareem A. Johnson, and 1 case is style of state of Texas versus Kareem Abdul Johnson. Now, Kareem Johnson was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., of course, bailiff called the name of Kareem Johnson at the courthouse door. Kareem Johnson did not answer Kareem Johnson has not appeared in court since the court has been in session. The time now is 11:48 a.m. on today's date of October 29th of 2025. Ms. Bailiff, would you please call the name of Kareem Johnson at the courthouse door?
Yes. Kareem Johnson, Kareem Johnson. No response, Your Honor.
Okay, Kareem Johnson's name was just called again at the courthouse door. Kareem Johnson did not answer. A reasonable time has passed to give Mr. Johnson an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
State moves for bond forfeiture on all four cases, Your Honor.
Okay. Kareem Johnson's bond will be forfeited. Warrant shall be issued for his arrest. And cause numbers 25 CCCR 1054, cause number 25 CCCR 1085, and cause number 25 CCCR 1086, and cause number 25 CCCR 0636. That's in response to the state motion to forfeit the bonds in those cases, which are granted by the court. Think that. Okay, I think that's it. Okay. Court will be in recess till we get the paperwork ready on it, please. Jefferson County Court at Law number 2 is back in session. The court is in session with 4 cases. They are cause numbers 25 CCCR 1718, cause number 25 CCCR 1719, cause number 25 CCCR 1900, and cause number 25 CCCR 1901. All 4 cases are styled the state of Texas versus Esperanza Zapata. Ms. Zapata, is that your full name?
Yes, sir.
Ms. Zapata, would you please raise your right hand? Ms. Zapata, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Ms. Zapata, you may put your hand down. How are you doing, Ms. Zapata?
I'm doing okay. How much stuff?
I'm doing fine. Thanks for asking, Ms. Zapata. You're represented in your cases by your attorney, Mr. Lawrence. How are you doing?
Just fine, Your Honor.
Hey, Mr. Lawrence, do you waive a record in Ms. Zapata's cases?
Yes, I do, Your Honor.
Okay, now, Ms. Zapata, I have before me in cause number 25 CCCR 1718, a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, Ms. Zapata, it alleges that you, Esperanza Zapata, on or about May 27th of 2025, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of theft of property that had a value greater than or equal to $100, but less than $750. Ms. Zapata, do you understand what you've been charged with?
Yes, Your Honor.
To this charge, Ms. Zapata, how do you plead? Guilty, not guilty, or no contest?
No contest.
Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Zapata, I also have before me a document on my tablet that is titled Misdemeanor Plea Admonishments. This document is also labeled as State's Exhibit Number 1. Ms. Zapata, do you recognize this document?
Yes, sir.
On page 2 of this same document, Ms. Zapata, there are a set of initials on a line next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that's titled defendant. Is this your signature? Oh, it's the trial court certificate.
I don't believe those have been printed, Your Honor.
The trial court certification? It should have.
There.
You gonna help me? Court certifications.
I'll give y'all time to fill it out. Ms. Zapata, I have before me a document that is titled Discovery Certification. Do you recognize this document?
Yes, sir.
And is this your signature
Yes, sir.
on the line that's titled defendant? Before you sign this document, did your attorney go over this document with you?
Yes, sir.
And did you understand everything that he went over?
Yes, sir.
Okay. Ms. Zapata, are you a citizen of the United States?
Yes, sir.
State other states one.
Any objections to State's Exhibit number 1?
No, Your Honor.
No objections. State's Exhibit number 1 will be admitted. Mr. Lawrence, you've advised and counseled Ms. Zapata. Is there any evidence that she is currently mentally incompetent to stand trial?
None at all, Your Honor.
And Ms. Zapata, your attorney, Mr. Lawrence, has advised and counseled you. Are you satisfied with his representation?
Yes, sir.
Has he provided full, effective, and competent legal representation?
Yes, sir.
Okay, Ms. Zapata, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement in this case?
We do, Your Honor.
And what is the agreement in this case?
State's offering 90 days probated over 1 year. Fine is to be waived, 40 hours community service and theft class with court cost, and we do have 4 days to be applied towards finding court cost.
Okay, 4 days?
Yes, Your Honor.
And the community service is just 40 hours, right?
Yeah, 4 days. Credit. This is 18, yes, 17, 18. What's court cost? Okay, and is there attorney fees in this case? Okay, $350.
Court cost $275.
Okay. 277.
Are you thinking?
No.
Are you saying?
No, I didn't come yet. I was just going through the file logs, so whatever he has. And I'm putting on this one. If I can get it to work. Yes, the services are going. If we can.
Ms. Zapata is indigent, Your Honor.
Okay, hold on. We have her affidavit. Oh, actually, that's gonna wipe that out.
Sorry. He's
Okay, Mr. Potter.
Sure.
I have before me, well, Mr. Potter, the state is offering that you serve 90 days in Jefferson County Jail, but you would not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you will not be required to pay a fine. The fine will be waived in this case. The court cost in this case is $277, but you've given 4 days credit toward the fine and court costs, which means that the court cost is already paid off.
Okay, sir.
And so you will be required to pay a probation fee of $60 a month, your analysis fee of $15 a month, reimbursement fee of $15, and court appointed, you'll be required to reimburse the court appointed attorney's fees of $350. Now, your total monthly installments is $115 a month. Are you able to pay the $115 each month?
She's indigent.
Okay, just need to access. You're not? Okay. Now, Mr. Potter, I have before me a document that is titled Affidavit of Indigence. I'm handing it to your attorney and he will hand it to you for you to review. Would you please review that document?
Okay.
Okay. You've already signed this, I think.
Yeah.
Is that you?
Yeah, that's me.
Yeah, okay. Now,
Yes, sir.
okay. Now, Ms. Zapata, is everything in that document still true and correct?
Yes, sir.
Okay. Let me see the document. Okay, hold on a minute. I need this. Okay. Okay, now, Ms. Zapata, the court is gonna find that you're indigent. And based on the finding of indigency, with regards to the state's offer of 90 days in the Jefferson County Jail to be probated for 1 year, the fine is waived. The court cost in this case is $277. We'll apply the 4 days credit toward the court cost, which means that you will not be required to pay anything because the 4 days has paid it off. When you has paid off the court costs. The attorney's fees in this case of $350 will be waived pursuant to Article 26.01 G-11 of the Texas Code of Criminal Procedure. The probation fee, well, the reimbursement fee in this case of $15 will be waived pursuant to Article 102.018 of the Texas Code of Criminal Procedure. The probation fee in this case will be waived because the court has determined that the payment of the reimbursement fee will cause the defendant, you to have a significant financial hardship.
This way.
Yes, pursuant to Article 42A.652. And you will be required to pay a year analysis fee of $180. So your total monthly installments, that is the total amount that you will be required to pay in this case is $16 a month. Will you be able to pay the $16 each month?
Yes, sir.
Okay. You will also be required to perform 40 hours of community service. You'll be required to attend and complete a theft class.
Okay.
This case will run concurrent with cause numbers 25 CCCR 1719 and cause number 25 CCCR 1901. Now, and the state will be dismissing cause number 25 CCCR 1900.
Okay.
And Ms. Zapata, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Ms. Zapata, I'll follow the plea bargain agreement that you have made in this case. Ms. Zapata, we will move to your next case, and that case is cause number 25 CCCR 1719. And in that case, Ms. Zapata, I have before me an information that was filed by the Jefferson County District Attorney's Office. And in that information, it alleges that you, Esperanza Zapata, on or about May 27th of 2025, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest. Ms. Zapata, do you understand what you have been charged with?
Yes, sir.
And to this charge, Ms. Zapata, how do you plead? Guilty, not guilty, no contest? Now, you're pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, sir.
Ms. Zapata, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a set of initials on a line next to a box that's checked. No contingent, which means no contest. Did you place your initials on this document? On page 3 of this same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, you recognize this document.
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes.
I also have a document that is titled Discovery Certification. Do you recognize this document?
Yes,
And is
sir.
this your signature on the line that's titled Defendant?
Yes.
Now, Ms. Zapata, before you sign and initial all of the documents that I just showed you, did your attorney, Mr. Lawrence, go over these documents with you?
Yes, sir. He did.
Did you understand everything that's in these documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
State up for states one.
Any objections to State's Exhibit number 1?
None, Your Honor.
No objections. State's Exhibit number 1 will be admitted. And Ms. Zapata, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do. Your
And what is the agreement?
State's offering 90 days probate over 1 year, fine is to be waived, 40 hours community service, and the 4 days Jefferson County Jail to be credited towards all fine and court costs.
Credit.
277, 75.
Okay, so Okay. Ms. Zapata, the state is offering that you serve 90 days in Jefferson County Jail. That will be probated for a period of 1 year. During the 1 year probationary period, you'll be required to, you will not be required to pay a fine because the fine is waived in this case. You are required to pay court costs of $277. However, you will not have to pay that because the 4 days that you spent in jail will be credited toward the court costs. Therefore, that is already paid up. It'll be taxed and retired. You are required to pay a reimbursed Jefferson County court-appointed attorney's fees of $75. However, because you are indigent pursuant to Article 26.05 G-11, that will be waived because the court has determined that you are injured and it will cause you to have a financial hardship, so you will not have to pay that. The reimbursement fee of $15, you will have to pay that. You will not be required to pay a probation fee because you're paying the probation fee, well, because one, the probation fee is waived pursuant to Article 42A.652. It's 42A.65. There's a subsection, hold on a minute. 652B, small b. And you will not be required to pay a urinalysis fee because the urinalysis fee is being, you know what? The urinalysis fee was paid in the other case, that you got probation on. Now, you will be required to pay a reimbursement fee of $15. Now, your total monthly installments is $1 in this case.
Okay.
Okay. Now, you will also be required to perform 40 hours of community service and adhere to the other standard terms and conditions of this probation. Now, this case will run concurrent with cause number 25 CCCR 1718 and cause number 25 CCCR 1901, and the state will be dismissing cause number 25 CCCR 1900. Ms. Zapata, do you understand the state's offer in this case?
Yes, sir, I do.
And do you think that what's the matter?
Is the community service in this, in addition to the other community service?
She has community service. I think what the probation department do, they usually run it concurrently. Yeah, they run it concurrent. At the same
concurrent.
time,
Yes,
yeah.
I understand that. Yes.
Okay. So, Ms. Zapata, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Yes, Your Honor.
Okay, Ms. Zapata, I'll follow the plea bargain agreement that you have made with the state in this case. Now, Mr. Potter, we will move to your next case, cause number 25 CCCR 1901. And in this case, Mr. Potter, I have before me an information that was filed by the Jefferson County District Attorney's Office. And in this information, Ms. Zapata, it alleges that you, Esperanza Zapata, on or about May 16th of 2025, while you were in Jefferson County, Texas, that you committed a Class B misdemeanor offense of theft of properties that had a value greater than or equal to $100 but less than $750. Ms. Zapata, do you understand what you have been charged with?
Yes, Your Honor.
And to this charge, how do you plead? Guilty, not guilty, no contest?
No contest.
Now, are you pleading no contest freely and voluntarily?
Yes, Your Honor.
And are you pleading no contest because you do not wish to fight or contest the charges?
Yes, Your Honor.
Now, Ms. Zapata, I also have before me a document that is titled Misdemeanor Plea Admonishments. It's also labeled as State's Exhibit Number 1. And Ms. Zapata, and Mr. Lawrence, I'm gonna make a correction on this document. It had it as a Class A misdemeanor. This is a Class B misdemeanor
Thank you, Your Honor.
theft. Do I have your permission to make that correction?
Yes, please.
Okay. Now, Ms. Zapata, this offense is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is confinement in jail in the Jefferson County Jail that does not exceed 180 days. A fine that does not exceed $2,000, or you could be given both such confinement and a fine. Ms. Zapata, do you understand the range of punishment for this case?
Yes, sir.
On page, now, Ms. Zapata, do you recognize this document? That's
yes, Your Honor.
the document I just made the change on. On page 2 of this document, there's a set of initials, EZ on the line next to boxes, check.
Yes, Your Honor.
No, the contender is that all these are your initials. On page 3 of this same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes, Your Honor.
And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document?
Yes, Your Honor.
And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that statement?
Yes, Your Honor.
Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement?
Yes, Your Honor.
And I also have a document that is titled discovery certification. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes,
defendant? Now, before you sign any of these documents, did your attorney go over these documents with you?
Yes, sir.
And did you understand everything that your attorney went over?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Any objections to State's Exhibit Number 1?
No, Your Honor.
No objection. State's Exhibit Number 1 will be admitted. Ms. Zapata, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is that agreement?
90 days probated over 1 year, fine to be waived, 40 hours community service and court costs with 4 days Jefferson County Jail to be accredited towards 5 months.
You say 4 days credit?
Yes, Your Honor.
$40 hours of community service.
Yes, Your Honor.
Let's see.
And all these sentences are concurrent.
Yes. Okay, now, Ms. Zapata, the state is offering that you serve 90 days in Jefferson County Jail. However, you're not be required to serve any time in the Jefferson County Jail because you'll be placed on probation for a period of 1 year. During the 1 year probationary period, you will not be required to pay a fine. In this case, because the fine is waived, the court cost is $277, but you have 4 days credit toward the court cost, which means you would not have to pay that because the 4 days credit has paid off the court cost. There's no attorney's fees in this case. And you will not be required to pay probation fee because you're paying it in the first case. You will not be required to pay your analysis fee because you're paying that in the first case. And you'll be required to pay a reimbursement fee of $15. Your total monthly installments in this case is also $1.
Okay.
Now, Ms. Zapata, this case will run concurrent with cause numbers 25 CCCR 1718, cause number 25 CCCR 1719. And the state will be dismissing cause number 25 CCCR 1900. Mr. Potter, do you understand the state's offer?
Yes, Your Honor, I do.
And do you think that the state's offer in your case is fair and just?
Yes, Your Honor.
And do you accept the state's offer?
Yes, Your Honor, I do.
Okay, Mr. Potter, I'll follow the plea bargaining agreement that you have entered into with the state. Yes,
You said she was what applying?
yeah, she's indigent on all her cases.
Yeah, but on this one here, you said the court appointed attorney. It's only.
Yeah, the way pursuant to Article 26.05 G-11. Oh, on this one?
Yeah.
On this one, she didn't have no court appointed attorney's fees, right?
Oh, she didn't. That's right.
Right.
Okay, so the reimbursement fee.
The reimbursement fee, she has to pay that.
Okay,
And she's not paying the probation fees because she's paying in another case. She's not paying the urinalysis fee because she's paying in the other case. And the $277, She not- no, because, yeah, well, because when you have probation running current, she only paid probation fee one time.
yeah, but that was.
And it was waived in the previous case pursuant to Article 42, 42A.652.
So am I putting that as waived in this one?
You don't have to put it because you can put it in there.
I just want to,
Yeah, you can put it in there. It's the same thing.
and that's it.
That's it. And, yeah. Now, Ms. Zapata, do you understand the state's offer?
Yes, Your
Do
Honor.
you think that the state's offer in your case is fair and just?
Yes, Your
And
Honor.
do you accept the state's offer?
Yes, Your Honor.
Mr. Potter, I'll follow the plea bargaining agreement that you have entered into with the state, and Mr. Potter, I'm signing the dismissal. You'll be able to get a copy of the dismissal in cause number 25 CCCR 1900 in a few minutes. Just have a seat and wait for your name to be called. You're welcome.
She'll go to probation, shortly.
Yes, and Ms. Zapata, once you finish your paperwork, you're free to go and you have a blessed day. And Mr. Lawrence, you're free to go as well and you have a blessed day.
Thank you, Your Honor. Here's my fee sheet, thank you.
And okay, this will conclude this session. The court will be in recess until 1 o'clock when we have our sentencing hearing on the next case. Okay.